professor here at Miller School of Business. And then I'll have our panelists give their introduction as well too. But before I do, I just want to ask the group, how many of you guys are in a relationship, not married relationship? How many of you guys are dating? Okay. How many of you guys are married? Okay, a few people that are married. Okay, so that's good to know. And so we're going to be covering some questions regarding love and money as when you're dating versus, and also like when you're also in a marriage as well too. So let's get started. So I have two individuals next to me, and so let's start by just introducing them. So let's start with Joshua.
Hello everyone, my name is Josh Brumley. I'm a personal injury attorney, and previously my practice was more general, and I did a lot of family law in Tacoma and King County, all over the place here. So I've done divorces and parenting disputes and a lot of that stuff, and that's sort of the value that I bring to the panel today. But all these goodies are really just related to my personal injury practice, so totally separate thing.
Hi everybody, I'm Kirk Mandlin. I'm a executive in residence here at the university. I teach a stock market simulation class the last couple of years. And next year, I think I'll actually be teaching a 4-credit class. So I'm very excited about that.
5-credit class.
5-credit class.
Even more.
4 credit for 5 credits. Different use of the word for. F-O-R, credit. In the day, I manage $180 million for about 180 families. So I have one eye on the market, but today both eyes are on you. So I'll be talking about the financial aspects of love and money, and at the same time, even though Josh is our expert in the legal department, I deal with the legal issues and really the family dynamics all the time. So you'll hear me weigh in on those as well.
Okay, well, let's get started. Now, a lot of men, you guys said that you guys are in a relationship. And so let's start with dating and cohabitation. Okay, so that's our first question. So when couples decide to move in together but are not married, what legal and financial safeguards should they consider?
Well, I'd say first off the bat, I think a lot of people move in to their significant other's home or apartment and might not be on a lease. A lease is the legal contract for someone to live in that property. So if you're not a legal tenant, you might not have the same rights as your partner who is the legal tenant. Getting yourself added to a lease will help prevent potential problems down the road. I really hate to be, I'm a very optimistic person. Hopefully every single one of your relationships works out perfectly, but the law doesn't get involved if things are going well. So my kind of feedback is always going to be pointed towards the worst case scenario, and to just prepare yourself so that it never comes up that you're in the worst case scenario. So protect yourself, be on a lease. That's very important to have the same legal rights as the partner that you're moving into maybe their home. That's my first bit of feedback about that.
If I can, I just want to step back. Today, dating is very different than when I dated. I've been married for 36 years. So I actually found my wife in a classroom. I took a math class. She was much smarter than I am, still is. And I thought she was not only smarter and might be able to help me in math, but I thought she was pretty cute too. And I still think she is. But today, you may know much more about the person you date, and you may know much less. Because through these dating apps, I think people can give you a sense of who they are. And at the same time, we know that's not always true. So what I'd like to first urge you to do before you ever think about moving in is have the conversation about finances. And it's uncomfortable. How many people like talking about money? Okay, good. Well, those two, you're going to do fine. The rest of us, like in my family, we didn't talk about money. And in fact, it was told to us it was rude to talk about money, and it was uncomfortable. But I think it's very important before you actually move in with someone to understand their attitudes about money. Because love can be magic, and love can be messy. And if you understand the attitude towards money, am I a spender or am I a saver? Do I like crypto or do I like gold? Just thinking of true opposites, right? Do I need security? That's a hint for all of us men that that's the most important thing to females. Or am I more of a gambler? Once you know that, you can start the conversation. And to talk about money, where are you money-wise? You don't want any surprises. We all have, I'm sure Josh has tons of war stories. My brother married a lawyer. Wonderful, love to have her in the family. And she came with $200,000 worth of student debt that he didn't know about. That should not be a surprise you learn on your wedding day, right? Or on the honeymoon. So you want to be very forthcoming. What do we think about, you're doing all this in dating. What do you think about where we should live? What do you think about travel? What do you think about living abroad? What do you think about children? You have to ask yourself, what do you think about money? Where are you? Where am I? So we go in with our eyes open.
That's really interesting because I'm kind of old-fashioned too. As a long time ago, people typically didn't live together before getting married, but now we see that more and more often. And people are really combining their finances. They're actually getting into rental contracts together. You talked about the importance of doing that. But as well as and it's not just they're buying furnitures together. They're on cell plans together. Mm-hmm. They're buying pets together. Oof. But then the reality is, people are living together. They're actually combining things together because it's financially more economical that way as well too. But at the same time, they're not willing to make a commitment yet in a marriage. But they're making commitment on a lot of other things.
Yeah.
So, I guess my question is, when it comes to sharing expenses and asset ownership, how do we protect ourselves? Because we're in a committed relationship, but not committed enough to get married, but we're joining all of these assets together.
Yeah.
Yeah.
In my experience, I think a lot of the people who are engaged in a committed, intimate relationship might not have a joint bank account, but are doing a lot of these joint asset ownership transactions. Buying a $2,000 couch where both of you split it. If you break up, who gets the couch? That's a question that hopefully you don't really have to figure out. But in the eyes of the law, you both own that couch, and one person has to buy the other person out of the couch, or one person has to agree to just give the other person the couch. That's between you guys in a breakup, but technically under the law, both people own that asset. A pet is a great example of something that probably should have its own category in the law, but pets, even though they're living creatures, are just chattel. They're just like a couch. The blue book value of your dog, my dog was $600 when I bought him with my ex, and we shared custody for like a year before she was like, all right, this is outrageous. And I was like, finally, I outlived this situation. But she didn't want to give him up. I didn't want to give him up. I was like, hey, he was $600. I paid for him. I've got the receipt. And she was like, well, he's licensed under my name, so I have ownership rights too. And we both raised this dog. It was really tough. And if you guys have pets together, you really have to consider that. There's no such thing as a parenting plan that the court's going to order for a couch or a dog or a cat or a guinea pig. And so you can agree to those things if both parties are reasonable. The problem is sometimes both parties aren't reasonable. And if that's a situation that you're worried about, have those difficult conversations before you're in the difficult situation of who gets this dog now that I'm moving out. Paperwork is really key in proof of ownership situations. If you bought the dog and you have the receipt for the dog, technically that's your dog. It doesn't matter that the other person paid for the shots and might have got the dog licensed. If it was only licensed in their name, maybe that's different. But a lot of people don't get pet licenses. You should. It's a requirement in Pierce County. But understanding that assets and pets are just assets are really, really tough conversations separate from who's going to keep going on this lease when we got this 2-bedroom apartment and now one of us is going to move out. So think about how that impacts you in the future before you make those decisions. I think a lot of people see a puppy and they're like, oh my God, it's so cute. It's so easy to take care of a puppy. It's going to add so much value to our lives. And then all of a sudden, 2 months, 3 months, 6 months, a year from there, you're calling me saying, what do I do about this dog that I need to keep from my ex?
Interesting. Okay.
Yeah, and pets they're emotional, right? We really love our pets. A couch is very much easier to split. Not every relationship is going to be 50-50, right? Because you may not earn the same. And so I think understanding who is going to contribute what. If I earn more than my girlfriend at the time, she moved into my place, just like Josh said, I paid the rent because I was working and she wasn't working. But we each kept our financial affairs pretty separate until we got married. She had her credit cards. I had my credit cards. By the way, mine were much higher in balances than hers. She's much better with money than I was at the time. I've gotten better with that. But it was an understanding of, I make this much, you make this much, and so is it 50-50? Is it 2/3, 1/3? What's going to be the breakdown? Who's going to pay for what? Because the more that you discuss it, the less chance you have to have a disagreement. And finances is one of the greatest drivers of dissatisfaction in a relationship. Right. So if you can just take that off the table because we've agreed to it, and then you're going to remove one of the strongest reasons to break up. I mean, it's sort of that and infidelity and some other things, but my grandmother always said money is like oxygen. If you have enough, you don't think about it. But if you don't have enough, there's not much else you can think about. So you always just want to make sure that you go in with your eyes open, you agree this is how we're going to do it. Keep them to the extent you can keep things separate. I have my credit cards, you have yours. By the way, think about this. Are we going to have a question, Doctor, about, or Professor, about marriage and what happens when the difference between marriage and, okay. So I'll save that comment. Yeah. So again, communication is key. Talk about it, agree to it, and then live by it.
So it seems like what I'm hearing is that, let me know if I understood it correctly, you guys don't advise joint accounts. You guys don't advise combining bank accounts before marriage. Is that what I heard?
100%. And what I think, when I bought a home with someone that I was not married to, and
you know what? A lot of people are actually purchasing homes before getting married. Let's talk about that.
Well, in that situation, we had a joint account that the mortgage payment came out of, and we would both deposit our share of the mortgage into that joint account. In that situation, my paycheck, her paycheck, they weren't going into that joint account. It was just the deposits for the joint bills so that we could track, like, hey, this bill is getting paid out of the joint account. It's on auto pay. We both put the money in. If one of us didn't put the money in, it was obvious to both of us. There was less risk of miscommunication or one person being less responsible, which, maybe you're just busy, you forgot to do the deposit. There was never any ill will, but that might cause a problem. And so in that situation, I don't think a joint bank account was a terrible idea. But with the way every person has Apple Pay, Venmo, Zelle, everything else now, it makes it so much easier to not worry about having joint bank accounts. The ability to transfer funds immediately is a really convenient thing that I think prevents the need of going into the bank, having a joint bank account, and then hopefully not, but at some point maybe having to close a joint bank account. What happens with the funds in that joint bank account? How do you close a joint bank account without the other person there? Do you really want to go into the bank on an errand with your ex and say, now we got to do this too? If you can just Venmo someone.
I know like you have a lot of thoughts on this, but then before I go to you, Kirk, I want to ask you, what are some legal implications of purchasing let's say, a home together
Yeah.
before marriage? I mean, like, what kind of things should they consider besides, who's paid for what?
Yeah.
But then, like, what's involved if you're not married and you're purchasing a property together?
So in my circumstance, we were both on the mortgage. And in my circumstance, we bought a home in Tacoma, and then the market went really poorly, and then we broke up. And I told you guys, I'm a very optimistic person. It's just a lot of my stories aren't beneficial unless I'm telling the sad ones. So we broke up, and it was not tumultuous, but we couldn't sell the home because the home was underwater. The mortgage amount was higher than the value of the home. So we were stuck owning this home as ex-boyfriend, ex-girlfriend for years. And, once or twice a year, she'd shoot me a text and be like, you get my name off that house yet? And I'm like, no, it's still $50,000 less than what the mortgage is worth. Hopefully some point Tacoma picks up and starts growing. And then eventually it did, and eventually I sold it, and she was very happy about that. She had already moved on, got married, had kids, and then was like, man, it's so good to have this chapter of my life closed. So if you can learn from my mistakes, just don't do that. But I don't know that it was a terrible idea when we were in that moment, because home ownership rather than renting was going to build wealth for hopefully both of us. Again, I was optimistic about the future, and it seemed like a responsible way to spend the money that we were already spending. We were already going to live together. It was either do we rent a property or do we buy one? And if we can qualify for buying a home, is that the right move? Another potential, and maybe this is more discussion you can have, but the first-time home buyer credits that we both used on the home that we both were getting for the first time, now we've both lost out on because that was both of our first-time home buyer credits. So if I had bought it and then maybe she had rented it from me, she wouldn't have been financially responsible if we ever broke up, but I might not have qualified for the loan in the first place with only my income. So it gets very complicated, but I guess for me, the answer to that question is if you can't afford to buy a home by yourself and you're not married, just don't buy a home.
Well, on that positive note, I'm just kidding. You know what I love is Josh is telling you real world, right? We've lived through it. If you haven't lived through it, so there is a sense of should you enter into a big transaction? If you're on each other's cell plans, not too hard to unravel that, right?
Right.
But if you're going to buy a house, and I literally have a client that emailed me last night and said, my boyfriend and I are thinking about buying a house. What do you think? First, you have to ask yourself, is it going to be 50-50? Because it doesn't necessarily have to be. So you can take title in your own name. And like Josh said, one of you rents from the other. It's not the most romantic thing. But if you have a lease and you can show the lender that you have a lease and that person has a good job, then they're going to give you credit for that rent towards your income. That helps. You can go in with joint tenants with right of survivorship, which is probably what you had. If one dies, the other one gets the asset, which may have wanted one of you or the other to think about that.
I'm sure she did.
Yeah. But it's also very uncomfortable if it doesn't work out, because then, and this happens with married people also, you are broken up, whether it's you're dating or you're married, and you get to tell your new boyfriend, girlfriend, significant other, by the way, I'm on the hook for a house we're never going to live in with somebody I don't love anymore, and you're probably going to hate. Because at one point, I was with them. And nobody likes their ex's or their boyfriend or girlfriend's ex, right? That just doesn't happen. So joint tenants, right of survivorship, anything happens to either one of you, it goes to the survivor. And then there's joint tenants in common. And joint tenants in common is very good when they're two individual people. It could be 50-50. Anything happens to me, it goes to my family. Anything happens to my girlfriend, it goes to her family. Or let's say I'm bringing 70% of the money because I have the bigger job. I can own 70% of the house and she can own 30% of the house. So joint tenants in common, you separate it by a percentage. Okay, you're still on the hook. Each of you is still going to be responsible credit-wise. But yes, you use up your first-time home buyer credit. You use up the ability to take money out of your IRA for a first home purchase, free of penalty. So you really have to think that through as to whether that's the best way to do it. Or should you just wait, bite the bullet, rent for another year or two until you're sure that this is the person you want to spend the rest of your life with?
And so basically, I guess like a rule of thumb is that, think about it really hard before you make a major purchase together.
Yep.
And just think about all the implications.
Yep.
Okay, so
I have a quick question.
yes.
So you're kind of painting the picture of that, if you're separate, that this is kind of, not something that you should get into, but I mean, it's really like a business deal that you're going into. I mean, your girlfriend, when you did sell, I'm sure she acquired something from that sale.
Nope.
No?
Because so we broke up, and then maybe 4 years later is when the house actually sold. When we broke up, she responsibly said, I know you're responsible with money. I know I'm not going to be involved in your life. We're both in agreement about both those things. I'd like you to sign a quitclaim deed so that you own the property and I have a defense if you default on the property saying I don't own it anymore. That doesn't absolve her of the mortgage, which is the debt associated with the property. It just gives her a defense if she ever needed to sue me if I stopped paying the mortgage and it affected her credit. So because she signed that quitclaim deed, she was like, I don't want any rights to this house. I don't want any benefits. I just want to protect myself in the future if you turn out to be a piece of garbage. And I said, cool, I'll sign that all day long. I know I care about my credit, and I know it's going to be very difficult for me to continue paying this mortgage without us living together, but I'm going to figure it out. And I did. And then 4 years later, when I sold it, that money was for me. And she and I had a conversation because she was still on the mortgage. So she actually had to sign the paperwork that showed how much I sold the house for. And she was like, I need you to sign something else that says this isn't going to be a part of my taxes because this home sale shows up as part of an asset that my name is on, and I didn't get any of this money, and I don't want to get paying your taxes for this money. And I was like, all day long, that's fine. I'll take all the money and take all the taxes, that's fine.
But had you not done the quitclaim deed,
Then
had she been helping with the...
Yeah, or even if I didn't do the quitclaim deed, or she didn't ask for a quitclaim deed, if I had been paying that mortgage for the entire time, but it was both of our home, I'm not entitled to just say, I'm keeping all the money. There would have potentially been a lawsuit about those proceeds. And so she was responsible for both of us to ask for that. I probably would have been fine splitting the money with her if she hadn't asked for it. But I think for her, it was more about the security of not being in fear that I was going to do something irresponsible instead of the gamble of hopefully at some point he sells this house for more money than it's worth and I can get a couple bucks. She wanted that security more than the gamble, which is something you already touched on, and that's really funny.
Yeah. Hey, Josh, talk about palimony and the idea that if I own my own home, but somebody else helps pay the property taxes or they pay the utilities, is there a potential claim that they could come in?
In Washington State, there is no right to own a property if you've there is a potential right to be reimbursed at least the money that you put into it. The idea of palimony, it's a play on the term alimony, which is spousal maintenance in Washington, and palimony means like my pal. But the idea of, do I pay to fix up your roof, and then at the end of you selling that house, do I get some money on top of what I paid? Without a contract, I think you're in really loose footing for that in front of a judge. Is that your experience as well?
That is, but there's been some very large cases, especially out of California.
Yeah.
Where there were big claims on really big assets.
Yeah. I think another thing that's really important is every state has their own state-specific laws. So California is a very different jurisdiction than Washington, and where the real property exists is probably the jurisdiction that you'll be in for any action about that property. If you're married in Washington and you bought a house in California and you get a divorce in Washington, well, the Washington court and the Washington law about that property is still going to govern that California property. But if you're a California resident and you bought a California home and you're going through a California divorce, Washington laws might be completely different than California's.
Does like a land trust or living trust, if the property's in a living trust, would that insulate you from any of those issues? Or?
Oh, you know what? That's actually a great question because
That's a great question.
that's going to be my next question.
Trusts and
too.
estates questions.
You
Gosh,
know,
you're touching everything today.
So,
Okay.
So like, you know, I mean, like, let's talk about estate planning and asset protection, and then, you know, I mean, we could talk about context of marriage as well as, I guess, dating as well too. So, you know, what are the essential estate planning tools that couples should consider, such as wills, trusts, what you talked about, power of attorney, to you know, I mean, like, protect your assets and to ensure that your wishes are followed.
After you.
Okay.
Right.
All right, good. So there are 4 standard estate planning documents that you should have. Everybody should have these. One is a will. And I'm going to come back. I'm going to do them in the order, and then I'm going to come back and talk about the will. So the will, what happens to my stuff if something happens to me? And we all hope to live a really long time, but accidents happen, especially if you're in a job that is very dangerous. So you have to plan for that. Secondly is power of attorney. If I can't make my own financial decisions, who do I want to make those? Again, conversation with your significant other of, I love you, but I feel better if my mom or dad were to do that, right? They've been at this a long time. They know me better. They know my wishes better. I want them to be able to do that. The third is a directive to physicians. What do I want done at the end of my life if I can't make those decisions? Do I want to have food? Do I want to have liquids? So hydration. Do I want to be resuscitated? Those decisions, and you write those all out. And the last one is a healthcare power of attorney. And that is if I can't make my own healthcare decisions and I haven't dealt with it in writing, who do I want to make those decisions? 4 standard documents. You can go to an attorney, and they're very good attorneys, and they charge for that service. If it's pretty straightforward, you can go to LegalZoom for about $75 and get the Washington State version of it, because each state is slightly different, and get that done. You fill it out. Some things are witnessed, some things are notarized, you have it done. And once it's done, you have peace of mind that your affairs, in essence, are in order. Now, the will has to do with how you transfer property in which there's no designated beneficiary or contract. A trust, which you alluded to, a living trust, is where I put my assets in a trust. Think of it like it has a wrap around it. Those assets are in there. They're protected from creditors and predators in some cases. And if something happens to me, or if I have an IRA and I set a beneficiary for my IRA, if anything happens to me, the property transfers by contract first. The beneficiary is set. We know where that's going to go. The trust is in the trust. It'll go based on the trust document. The will is for what's left, the residual, and then it's by law. And if it's over $100,000 in property, you go through probate. Probate is a court action. Takes a year or so, 2 years, costs about $3,000 to $5,000. There's some filings that you have to do, and but then everything else gets distributed at that point. And now let's see how good I did. What do you think?
So, 10 out of 10.
Good.
It's like you went to law school. Wow. The only thing that I could think of to add to that, the probate process is something that I think a lot of people prefer to hire an attorney for instead of do on their own.
Absolutely.
It does require, if you're going through the probate process, a physical in-person court appearance. And so I think $5,000 is maybe a low estimate. I'm not a probate attorney, but in Pierce County right now, the going rate for an hourly rate for an attorney is about $400 per hour. I don't know anyone doing probate work for less than that. I know attorneys doing it for more than that. And if you shopped around, you might be able to find someone for less than that. But I also know a lot of very new attorneys who are like, oh yeah, I can do that all day long. And for $400, they'll draft your will by going on LegalZoom and paying $75 to draft your will and then giving it to you. So just be aware that maybe the lowest price attorney is low priced for a reason.
Yeah. Yeah. Good legal advice is not cheap, and
Cheap legal advice is not good.
That's exactly right. A good attorney online says that all the time.
Did that answer your question?
Yeah.
So I'm just alone.
Hang on one second. We have one
more
question over here.
Yeah, I was just wondering if you could go into a little bit more detail about the circumstances of how you get to in what circumstance would a property go into probate? Like, I've heard about it, but in the context when I hear about it, it's usually a grandparent passes away and things weren't set up properly, and so it ended up going to probate. So what does that mean?
I don't think that there's a requirement of set up properly that triggers this. I think in my experience, it's the value of the asset. So over $100,000, it's required to go through probate. If there's a trust or some contract that governs where this goes, then maybe it can be excluded from the probate process. Is that your understanding?
So the state of Washington a few years back created what's called a TOD, Transfer on Death Deed. So if let's say you have a grandparent and they're single, right? So if you're married, generally it's joint tenants right of survivorship, husband and wife, it goes to the survivor. There's no probate for a survivor. They just inherit everything. It's when there's a single person on the deed and they pass. If they don't have a beneficiary designated and the value of the equity, what it's worth minus what you could sell for is more than $100,000 of all of their assets, then you're forced into probate. You can always open probate, but then you're forced into it. So what one can do is a transfer on death deed. What does that do? It sets the beneficiary. If anything were to happen to me, this goes to my children, 1/3 each to these three, or it skips that and goes to my grandchildren. It doesn't matter what it is. We do transfer on death agreements in our accounts for taxable accounts. And if anything were to happen, it transfers directly. It doesn't go to probate because that all transfers first. An IRA has a beneficiary. Oh, by the way, a bank has a POD, pay on death. Same idea. You set the beneficiary if anything were to happen to you. An IRA has a beneficiary designation. If anything happens, this is who my account goes to. And those all transfer free of probate because you have in essence, a contract, and it transfers there. So it's only when you haven't done that planning, you haven't done that step, that then you could be forced into probate. You bet.
And in my experience, as limited as it is, and believe me, it's limited. I don't practice in this area. I've been in a courtroom while other people are making their case and just get to observe these arguments being made. The probate process, when you have multiple people trying to get the same asset, changes the cost of the probate process. If everyone agrees, the probate process is quick. What happens if there are multiple people who all want the house? And now it's like a divorce between siblings where everyone's fighting. So there are clauses in wills that say if you object to this dissolution process, then you'll get nothing, to try to protect after someone passes away the possibility of all of these heirs then going at each other's throats to try to take more than what was intended for them because they feel like it wasn't a fair thing, or, well, earlier the will said this, and when they changed the will and made it 1/3 for all of us instead of 100% to me, they weren't in their right mind, and so they were taken advantage of by my siblings, and now they're objecting to this 1/3 split. Those are really ugly family law probate process problems that are incredibly common. Incredibly common.
Josh, I'm glad you brought that up. So everything we're talking about today is how not to get into a legal issue, because those are expensive to litigate.
Yes.
Yeah. One thing I want to just bring to your attention is, and the university is actually going to take the lead on this next year through the accounting department, is elder financial abuse. We have seen where you have a grandparent or a loved one that's older and they have a caregiver. And that caregiver becomes very important to them, or they get a new friend. And the new friend comes and visits them much more often than the family. And then the person wants to leave their estate to them. Very, very difficult. So I want you to be careful. Why is it difficult? Because the grandparent, may not be in their right mind. They may not have 100% of their capabilities and their capacity, the legal term for capabilities, and then you're trying to put the snake back in the can because it's a mess. And so you have to be very careful of our older folks because they're easily tricked. They're tricked for romance scams. They're tricked for scams with regard to taking care of their house. Someone says you need a new roof. I can have a crew here tomorrow. I just need half down. They write a check. We never see them again. They're scammed with regard to caregivers. And believe me, we're all, caregivers do work that none of us want to do, right? They're in charge of taking care of our loved ones so we can go on with our lives. But you have to be involved with those people, those loved ones, to make sure they're not being taken advantage of.
So hopefully, like this education that you get here, like you can apply towards your grandparents or your parents as they get older, because just like Kirk said, they are very easily influenced. Right?
Well, I hate to just keep bringing up all my personal experience here, but Dan, my grandmother passed away almost 2 years ago, and my grandfather is maybe 15 years younger than her. Props to her. She got a hot young guy. And he's, I believe, still got very good capacity. He's in his 70s, and I don't know, maybe 2 months after she passed away, he's living alone. He called me and he said, I need $15,000 for new windows. And I was like, what do you need new windows for? Did something happen to all of the windows in your house? He said, no, this really nice guy came to my house and he said, I really need new windows to protect from the storms that are coming this winter. So I signed the contract already, and I was like, oh, hold up. What? You signed a contract for $15,000 and then just picked up the phone and thought I was going to pay you $15,000? Yeah, I'm a good grandson, but not that good guy. So I had him send me the contract, and these contracts actually have like a time period where you can get out of them without any problem. It's a short time period, but because those in-person sales are so predatory and they get to be so pushy, and they usually go to someone's home that is maybe very recently experienced a loss, they're just lonely, they start to be friendly to them, they say, oh, you seem like a really nice, trustworthy guy. Okay, yeah, I'll sign for new windows, no problem. So my grandfather has the same windows, and he could care less about his windows, I think, but.
So one common thing that I'm getting here is that, like we need to stay in communication with all of our loved ones.
Yeah.
And this also includes your significant other as well, too. And one thing that Kirk mentioned is that you have a sister-in-law or somebody, I think you mentioned yesterday, somebody married an attorney, had a $20,000 student loan.
$200,000.
$200,000 student loan, yes.
$20,000 would be nice.
Yeah, $20,000 would be nice, yeah. And so I'm going to talk about student loans. I know that we didn't really touch up on prenuptials or anything like that since we're running out of time, but I do want to talk about student loans. And I mean, what are the potential implications of a student loans in a marriage? Let's say like one person brings in $200,000 student loan and the other doesn't. How does that work? What are the implications?
Well, there's the moral implication, and then there's the legal implication, right? Because my brother loves my sister-in-law, right? Yeah, and they've just had to work through it. And he was like, "Wow, that's a real surprise," and they're paying it off, and they're going to pay it off, and they've had lots of conversations about it, as you can imagine. That's the moral obligation. Now, if they break up, she probably takes the loan back with her. He takes his assets with him. They split them up. I don't know if there's a legal claim to your assets for that. But you mentioned prenuptial agreements. if you are older and you're going to get married, especially if you have children, it's not bad idea. It's not a bad idea to have an agreement. This is what we come in with. If anything were to happen, this is what we go home with. People hate having that because it's not very romantic.
No.
That's why I say always just put it on me. Just say, hey, look, Professor Kirk said I have to do this.
My financial planner said I have
that's
to do
right.
this. Yeah.
It's just something we have to do. If you're an ultra wealthy person, it's expected that you will have that type of agreement. But if you have children and you're on your second marriage and you have a house coming into the relationship, it's a very good idea to have an agreement that if something goes wrong, and by the way, you're never going to get along better than that day. Okay? So that's the day to get it done. And if you need to blame somebody, blame me.
So with coming into a second marriage, and you each have your own property, that's property that you obtained before, it's each in your own separate names. But then when you marry, that still stays separate, correct?
Washington's a community property state. So any assets that you go into the marriage with that are separate assets, you could say are separate assets. What if you had a home and then this new person moves into that home and then they start paying the mortgage after the marriage? Now they've got a right to that property because they were paying the mortgage and they are married to you and you're the owner of the property. I'm not saying that they'll be successful. I'm saying that they have a claim. And that's a really important distinction, right? People always ask me, can I sue for this? And my answer is absolutely yes. No matter how ridiculous anything that you can think of is, can I sue for it is not really the question you're asking. Will I be successful suing for this is really the question. People are successful suing for things that they shouldn't be successful on all the time because it costs money to defend against a frivolous lawsuit. I don't know if that's super clear to people, but the cost to defend against a lawsuit that isn't proper can sometimes exceed the benefit of being successful defending against that lawsuit. So people file lawsuits that they know they can't win to muscle you into giving them what they want. So yes, there could be a claim. Whether or not they'll be successful is a different question. Do you want to pay an attorney $400 an hour with $10,000 down up front to start the process about fighting it? Which is what McKinley Irvin, Tacoma family law firm, charges to start the process for any family law case.
You also then inherit each other's debt too, and had separately?
If you have a contract that prevents that, then maybe no. If in the divorce you agree that both parties take their own debt, then no. But what happens if you don't agree? I mean, most divorces are not agreed divorces, right? Someone's pissed off. And if someone's pissed off, they're probably not going to be their most professional and agreeable self. And
student loan, can they become a common loan when in a marriage?
I don't think so. I'm not the
think so.
expert on student loans.
Well, and who knows what's going to happen with the Department of Education anymore anyway,
No,
right?
I'm just wondering, like, if like a one partner brings in a student loan, and also if you're paying off that student loan with a joint account,
Yeah.
at some certain point, do you both become liable for that student loan?
I don't think that
never
the
did. I don't think so.
liability
Okay.
changes. I think that the question that we've seen in family law is if I'm the working spouse and the other spouse is going to college and then they have a $200,000 law school debt and then they become a lawyer and then in their first year of making $400,000 a year, they say, surprise, I'm getting a divorce. The partner that paid for both parties to live during that marriage probably has some rights to that future income that they helped that person build. But that's very state specific, that's very case law specific, and it's very time of marriage specific. Washington breaks your marriage into short-term, mid-term, and long-term, and anything over 10 years, you have a lot more rights than anything less than 10 years, and anything between 1 and 3 years, you basically don't have those really big community property rights. So if it benefits you to get the divorce right now, do it.
Yeah.
If you need to wait, then, wait.
You know what? There's a reason why you married that individual.
Love, yeah. Just
Yeah.
go to counseling, guys.
Yeah,
just do that.
exactly. I mean,
Don't
let's
take-
just spread the love.
Yeah. One other thing I want to highlight. After you're married, as Josh said, if you take on a debt, it's a commingled debt. It's community property. If you have an asset, it's considered community property. The one time it isn't is when you inherit money. So even if you're married and you inherit money, you can continue that money as separate property. And that makes for an uncomfortable conversation. And that's why I always have to meet with the person that inherits the money separate from their spouse.
I've had that case in a divorce where the spouse wanted to split that separate property because they knew it existed, and they got a divorce after it existed. And while they maybe didn't have any rights to it under the law, that doesn't prevent their attorney from asking or demanding or negotiating or relentlessly filing motions that cost the person who's trying to protect that asset from spending it to just defend it. It's chess, and it's sometimes not fair.
There's a couple questions up here.
Would that also include if, let's say, I get married and my spouse starts a business?
Mhm.
Would that also include, like, if whatever money they make from that business,
Mhm.
and we decide to get a divorce?
You mean the sense of the community property? Yep, because it happened after the day you were married.
I was gonna say with that same example of if somebody inherits money, what about property like a house?
Any property.
Yep.
Yep, it can be
Financial or
again.
real
You have
property.
to defend it, but
Yeah.
but the law is that is separate property. But you don't put the other person's name on it. You have
When
a
you start to
separate account.
commingle it is when it starts to be more blurred.
Yeah.
You keep it separate, then you have the best defense.
2 more questions
Yep.
over here and right here.
I was just gonna point out that piece of, you have to keep that money separate.
Mhm.
You inherit the money and then you put it in your joint account, then it becomes joint.
That's it.
Okay.
The minute it goes in, you give up 50% of it.
So say somebody's lucky enough to win the lottery.
Yep.
Is it better to keep it secret, never tell them about it, or is it better in that way, have that contracted and discussed?
I'm going to look at the camera and I'm going to say, never keep secrets from your spouse.
That's it.
But if you're unmarried, man, like that's a whole different ball. No, I'm just kidding. I think that winning the lottery is different than inheriting money. And inheriting money is based on the familial relationship you had with the person who passed away. Winning money at the casino or gambling on the lottery or what's the bingo? The bingo hall that's right down here. It's not the same benefit of being able to be claimed separate property. But if you're unmarried, then they have no right to it.
Yep.
It's just what you want to be generous and say, let's go to Mexico. Come on, let's celebrate. I won the lottery.
So we're coming up on the hour, or the 1:20, and that's when we're supposed to end. And so I just want to say, is there a last piece of advice that you want to leave with this group? Just a final piece of advice, before we end.
The biggest decision you're going to make in your life is who you marry. Not which school you go to, not which business you go to work for. It's going to be the person you marry. So think about it.
I think that that's a very astute observation to really take to heart. I think a lot of couples right now in this area, based on my experience, are still having children together without being married. And there are legal implications to that are totally separate. Without a parenting plan in place, both parties have equal rights to that child. And your spouse, who you were never married to, could take that child and leave to Mexico and never come back, and it wouldn't be kidnapping. Get a parenting plan if you're unmarried and have children. And similar to that conversation, don't have children unless you're sure this is a great person to have a child with, so that they don't take the child to Mexico and run away forever.
Well, thank you, everyone. Joshua and Kirk's going to be here for a while if you want to come up and ask questions afterwards. But thank you very much.
Thank you.
Yeah.